That's extremely difficult to do, and it's not clear why Senator Craig would have any plausible argument for reopening it. After all, the facts of the case haven't changed. There haven't been any new evidentiary disclosures. The law has not changed. I mean, what's changed is he kind of has, guilty plea remorse. I mean, he's sorry that he pled that way, but that happens every day just as well, that people change their mind about a plea. And if he says he knew at the time that he actually was not guilty of the crime or didn't commit the offense or didn't do the acts alleged, and he said that he did, now he's exposing himself to a perjury prosecution. Well, I think he has a better chance of being reelected to the Senate in Idaho than he does of getting a court to throw out his initial conviction. If he's not going to go in with an entrapment claim, and he's not going to claim that there's a constitutional right to engage in sex in public, both of which are plausible, it's very hard to see why a judge would be interested in throwing the charges out and throwing out the conviction and starting over again, especially when he has now made this the trigger for his decision about whether or not to resign from the Senate. At that point, a judge is going to say, hey, that's too much power. I'm not going to take responsibility for whether or not he stays in the U.S. Senate. I'm just going to stick with the judgment as it's already taken place. But we're talking about a guy who's a U.S. senator, who makes laws, who analyzes complex legislative language every day. How can he assert that he didn't understand what he was signing or what he was pleading to?